Hello, everyone. This is Mary Jones, Senior Education Consultant with Husch Blackwell's Education Group, and we'd like to welcome you to today's webinar, Planning for an Uncertain Future, COVID-19 Concerns for Campuses. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. Let me just take a moment to highlight a few of those key resources for you. There's an icon to assist you with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the Maximize icon at the top right of the slide area, or simply drag the bottom right-hand corner of the slide to adjust it. If you have any technical difficulty, please click on the Help icon. It has a question mark and provides information regarding common technical issues. We have found that using the Chrome browser works best, and if you have any technical issues, please try refreshing your screen first. You'll notice that we do not have a question box for this program because our attorneys are already answering questions that we've been receiving. We have elected to leave that off, but of course you can always contact your Husch Blackwell attorney with any additional questions or follow-up. But we do thank everyone who's provided questions for this webinar today. The resource list icon looks like a folder at the bottom of your screen. It includes a handout with a list of questions being answered today during a webinar that might help you with notes. We've also provided some Husch Blackwell resources to support your efforts in responding to the pandemic. This program is approved for Illinois, Iowa, Missouri, Nebraska, Texas, Tennessee, and for continuing legal education credit. This pending approval for Wisconsin. Once everything's ready, we'll update the certificate of attendance link with the automated email that you'll receive tomorrow afternoon. To report your hours in Illinois, Nebraska, Tennessee, or Texas, make sure you click on the CLE widget at the bottom of your screen and complete the questions. And you may also download the certificate of attendance from the certificate widget that's also on your console at the completion of today's program. A recording of the webcast will be available tomorrow for watching and sharing, and once available, we'll email a link to you for the recording. Our speakers today include attorneys from our higher education law group here at Husch Blackwell. We have one of the largest such practices in the United States. Our attorneys have decades of experience resolving the most complex challenges confronting colleges and universities. Several of our education attorneys have gained valuable industry insights, and they've served as in-house counsel at educational institutions, major corporations, and government agencies, including the U.S. Departments of Education, as well as Justice. Today, we've invited several of our attorneys from all over the country to address your questions, and we have arranged our webinar by topic. To save time, each attorney will go ahead and introduce the next speaker. So with that, I am pleased to introduce the leader of our higher education group here at Husch Blackwell, Haley Hansen. Haley, we know these are challenging days for everyone on our webinar today, and we are looking forward to hearing your guidance.
Thanks, Mary, and welcome everyone to our webinar today. Today, the focus of our town hall is really going to talk about financial considerations and preparing for a post-pandemic world. And we've given you a slide here that is an article from the Chronicle of Higher Education. We've also seen similar articles come out from the Wall Street Journal and the New York Times, really saying what is this going to look like for higher education. Today we really want to focus on some of those financial issues and questions that you may all be struggling with. So let's go ahead and get started and talk about our agenda for today. So we're going to focus on, again, financial aspects, dealing with academics, really mitigating risk and liability, talking about finance and financial exigency. Then we're going to talk a little bit about the stimulus package and monies that are available to institutions, and finally end with contracting. The first question is, will moving to pass-fail grading or credit versus no credit impact programs? And as you can imagine, the answer to that question is fairly complicated. First, institutions should determine what their policies allow for regarding pass-fail courses. And if there's exceptions that may be made, they should follow appropriate procedures while getting faculty input about making exceptions and policies. Guidance to date indicates that the department isn't going to dictate how schools should treat their classes for satisfactory academic progress purposes, so you should still continue to follow your SAP policies. Accreditors, for the most part, have shown remarkable agility in adapting to COVID-19. HLC has said, for example, that temporary altercations to policies and procedures are permitted as long as institutions are documenting their decisions and allows them to kind of retrace their steps when this crisis has passed. And so they really want to focus on the documentation and allowing students to move forward. So I think that's very important. HLC has specifically said it's not going to opine on institutional decisions related to assignment of grades beyond the more general requirement that academic integrity be considered and followed, and that there's academic rigor to the programs. So that is how moving to pass-fail grades has been interpreted. The next question, can I require faculty to teach more than their normal teaching load? The answer really depends on what you mean by normal and ultimately what the faculty contracts and handbooks say. For institutions, their faculty contracts and handbooks that do not specify the number of courses that faculty are required to teach each year, then you will have much more flexibility in adding to that load, so to speak. So if your contracts and your handbooks are silent regarding the number of courses, you are going to have much more discretion to address the exigent circumstances created by COVID-19. Faculty may not be happy about this, but absent express language limiting the number of courses they were required to teach, they'll have a difficult time challenging a reasonable increase in hours. And be mindful that you've got to be reasonable. A dramatic increase in hours, for example, doubling the normal teaching load, would likely be viewed as outside the bounds of a reasonable interpretation of the contracts or handbooks at your institution. For institutions whose contracts and handbooks specify the number of hours to be taught each semester, you may have more limited options. If the handbooks specifically have a fixed number, then increasing that number beyond the specified numbers in the document could actually result in a breach of contract. So you need to be very careful about that. If the contracts specify a normal or target hour, but leave some discretion to the institution, then it may be permissible, but you want to make sure you're talking with your counsel about that before making that final determination. The last question I'm going to answer today is whether or not an institution can launch a new program during COVID-19. And the answer is yes. If you've already received the necessary approvals for the new program from your accrediting agency, you may move forward and launch new programs during COVID-19. However, it's important for you to consider how COVID-19 will impact the delivery of your program, and you may want to create curriculum that can be used both in person and online. Also, if your current approval for the program only contemplated the program being delivered in person, you may now need to offer it online due to COVID-19, so you need to make sure that you're notifying your accrediting agency or state regulatory authority that you're making temporary adjustments and following all the steps that that agency requires you to do. You also should keep in mind that if a new program is preparing a student for a licensure, a certification, or a qualifying exam, you may need to double check whether certain courses can be offered in an online format based on state licensure requirements. And specifically, one of the examples we've seen recently is in nursing, and there's been a lot of information put out that the requirements for in-person clinicals have been suspended in many states, and that they can now do those virtually as well. And so look at those requirements as you're launching new programs. And lastly, we really encourage you to update your policies, including what's in your catalog or syllabi, to inform students regarding how course content may be temporarily delivered due to COVID-19. And look at those policy statements and make sure that that information is covered. Next, I'm going to turn it over to Scott Schneider, who's going to talk about mitigating risk and liability. Scott?
Thank you, Haley. So my question is, if we return in the fall and someone on campus has COVID-19, will we be liable for someone else becoming ill due to exposure? And so this one is an absolute doozy of a question. So for starters, I will point out that clients have probably asked me some version of this question the most over the last several days. And I'll reword it a bit. What does a safe return to campus in the fall look like? And the short answer is it's complicated, but I also think it's precisely the sort of remarkable challenge institutions of higher education are especially well suited to potentially tackle. So first up, of course, state and area-specific guidance may ultimately constrain institutional options here. If you live in a state or a city that says no on-campus classes this year, well, suffice it to say, your options here are limited. We also expect that there will be very specific guidance coming from the CDC about what a safe return to school, both in terms of K through 12 and higher education, may look like. To some extent, complying with that guidance may be something of a standard of care. In other words, if a school disregards or fails to monitor and comply with federal, state, and local guidance, that would be, in a word, problematic. In terms of relevant case law, I've researched this. There are very, very few cases in which students have brought lawsuits against schools after they contracted a disease from another student or other school community member. In the K through 12 setting and in a slightly different context, perhaps the best known case that we have is the Second Circuit's 2018 opinion in Munn v. Hotchkiss. That case involved a school which brought a minor child to China on a summer program. The student, while on that program, was bit by a tick while the student was on a hike, suffered encephalitis, and ended up being unable to speak. The court in Munn stated, every public school shares this common sense duty to protect the health and safety of students in its care, and that Hotchkiss School knew or should have known the dangers that ticks posed in China, and they were found liable. Hotchkiss School was found liable for failing to properly warn Munn or her family of these dangers, and Munn was awarded a $44 million jury verdict. Okay, so that gives you some perspective and context here. Of course, that case arises in the K through 12 setting and has some unique facts, so the extent to which it may or may not apply to higher ed is unclear. But the case gives you a flavor for what tort litigation may look like in this space. Namely, there may be a duty of care to warn about the risks of COVID-19 on campus and how those risks may be different from generalized off-campus risk to the extent they are. And from a more complicated perspective, what are the reasonable steps that schools need to take in order to minimize the risks of COVID-19? What might those reasonable steps look like? Again, we suspect we will get some guidance from CDC on this in the coming months, but for schools considering the issues now, some of the ideas being tossed around include moving the fall semester starting date back, taking all large classes online. For in-person classes, ensuring there is social distancing within those classes. Requiring students and other community members to wear masks when social distancing is impractical. Using data compiled through a variety of tools to monitor potential outbreaks. Developing protocols for what happens to students if they test positive or are exposed to someone who may have tested positive. Being candid about the risks of being on campus. Providing online options for students who want to continue with their education but can't return to campus. And ensuring that the campus has appropriately staffed and trained campus health centers. Suffice it to say that the challenges of this are daunting, but there are a number of schools who have decided to embrace the challenge and have already started the process of searching for solutions to bring students back in the fall semester while at the same time managing risk in this space. All right, so that leads me to my second question, which is, can we do temperature screenings when we reopen in the fall? Not only can we may have to. For instance, several states and local municipalities have implemented orders or issued guidance urging or requiring that temperature checks be implemented before employees are permitted to report to work. There were some concerns at one point about the ADA implications of this, but the EEOC has issued guidance confirming specifically that the COVID-19 pandemic permits employers to measure employees' body temperatures before allowing them to enter a work site. In conducting these screenings, it's important to point out that they be implemented in a non-discriminatory fashion and that the information gathered should be treated as confidential medical information under the ADA. Specifically, the identity of workers, employees exhibiting a fever or other COVID-19 symptoms should only be shared with members of the university community on a need-to-know basis. Additionally, keep in mind that fever screening is just one of the screening devices that schools may utilize and will not completely mitigate the risks of contagion, as some people with COVID-19 do not have a fever and may also otherwise be contagious without experiencing any symptoms. Finally, it's important, if we're going to implement temperature screenings, that we have that done by trained personnel and that there are clear metrics for when an employee will not be allowed to return to work.
Thank you very much, Scott. I'm sure most of you have heard about the spate of lawsuits, like the one filed last week against the University of Miami, that are class actions seeking a refund of certain tuition, fees, or other costs paid by students. These lawsuits rest primarily on a breach of contract or unjust enrichment theory based on the failure of the defendant institution to provide in-person education, room and board, or other services. While there are many possible defenses should such a lawsuit be filed against your school, what I'd like to do today is discuss a few of the things that you might do to try to reduce the chance of a student bringing such a claim in the first place. Let me offer 4 quick suggestions. First, show leadership by communicating a message of hope and community to your students. They're feeling some of the strains that all of us are and are looking to you for guidance. Second, find ways to remind students of what they love about your school through photographs, videos, or virtual events. For example, present a virtual musical or literary event. Or, if you're a religious school, offer virtual services appropriate to your denomination. Third, keep in touch with students and offer them options. For example, one institution is using an online tool to check in anonymously with students about their online classes, their mental health, and even their safety and food security. The school is then trying to find ways to meet the identified needs. In contrast, my son, who's home from college, had trouble finding the online lectures for his math class and did not have easy access to answers. That kind of situation can lead to frustration. Fourth, consider communicating about future in-person plans and opportunities as you develop them, even if they may be far in the future. Generally, just like when students are on campus, try to keep them engaged on multiple levels. If you do this, keep students engaged, communicate with them frequently, remind them what they love about your campus, you'll reduce the risk of litigation by reducing the frustration level of students. Let me turn now to a much more specific challenge that some of our clients are facing: deciding what to do about clinical students who are placed in COVID hotspots. This issue has actually already arisen. What one institution did was smart. They identified an alternative placement for the student. Unfortunately, the student chose to stay in the hotspot and became ill. Not only that, but the student has threatened litigation against the school. While it's impossible to tell whether such a claim will be ultimately brought or could be successful, we think the school is in a much better place in terms of risk mitigation because it did identify an alternative placement for the student. So if you have clinical placements in hotspots or in institutions where a significant cluster of cases arises, what should you do? First, identify and offer appropriate alternative placements. Second, encourage the student to take a safer placement if possible. Third, if the student insists on staying in a hotspot placement, make sure that CDC guidelines are being followed. With that, we're going to transition from liability and risk management concerns to some financial issues related to planning during this pandemic. And with that, I'll turn it over to my partner, Lisa Parker.
Thanks, John. So our next question is, our budget is likely not sustainable with no housing revenue and or reduced enrollment. What are our options? So as a lawyer, I'm going to answer this question from a legal and regulatory perspective, but I think it's important to acknowledge that we are hearing these types of concerns from many institutions. And the truth is that the COVID-19 crisis is hitting higher education very hard, and it will be important for each institution to assess its own particular circumstances. So first, if your institution typically has stable financials and generally meets its annual operating budget, you should take some comfort in knowing higher education regulatory authorities, such as your accrediting agencies and the U.S. Department of Education, fully understand that this crisis will have a negative impact on institutional finances. So, for example, the Department of Education has informally told institutions that have inquired that it will be issuing guidance related to federal financial responsibility composite scores that apply to private institutions. So this means that if your institution is concerned that the crisis is going to tank your composite score, please know that the department should be releasing some guidance on this issue, and hopefully that guidance will result in some temporary relief from composite score requirements. If this happens, we're guessing that accrediting agencies are likely to follow the department's lead with respect to its own methods of scoring financial stability. Now, if your institution already was struggling financially and is concerned that COVID-19 will make a challenging financial situation worse, we recommend that you begin to prepare and document a plan for financial recovery, as this is what your regulatory authorities will expect you to do. So for some institutions, that may mean closing programs that are losing money while launching new programs with more growth potential, or it could mean hiring freezes and reductions in employees. But as you plan, be sure to consider how your strategy will impact your overall finances. For instance, you may reduce your employees, which could decrease your payroll, but this may lead to other costs, such as paying out vacation time terminated employees had accrued. Also, there are two strategies that we keep seeing institutions employ for which we'd advise some caution. First, if your institution has an endowment, you may be considering utilizing endowment funds to cover shortfalls arising from COVID-19. Please be careful in doing this. Make sure that your use of endowment funds aligns with your endowment policy and that any deviation from this policy is a short-term solution that you're going to document. We've seen a trend of accrediting agencies raising concerns over these types of actions, even leading to sanctions if an institution regularly makes endowment draws of greater than 5% to cover operating expenses. The other trend we're seeing is that many institutions are seeking to launch online programs by partnering with companies that assist in developing and hosting online programs and recruiting online students in exchange for some split of tuition revenue. These arrangements are really attractive to institutions as they may not require any upfront capital from the institution. While these types of arrangements may be beneficial, it's really critical that you ensure that any of these agreements comply with federal regulations and accreditation requirements. If this is something you're considering, we really recommend your legal counsel review this agreement to make sure you're in full compliance, as these types of agreements are really starting to get a lot of scrutiny from regulatory authorities. So the next question also comes from a financially challenged institution. And here it looks like an institution is considering a merger or a consolidation with another institution, or perhaps a partnership to share academic or administrative functions in order to cut costs. So in this situation, what is important to keep in mind is that if two institutions are considering a transaction or partnership, and if what is being contemplated will require prior approval from accrediting agencies, state higher education authorities, or the U.S. Department of Education, then one of the factors these agencies will assess is finances. So at a high level, if one institution has very weak finances, it will be important for the other institution to show financial stability. Also, it will be important for the institutions to be able to show that they have the financial ability to complete the contemplated transaction. So, in other words, following consummation of the transaction, will there be the ability to cover any debts or financial obligations going forward? In particular, if the U.S. Department of Education approval is required, the department will apply financial tests, such as evaluation of the Federal Responsibility Composite Score. And if these tests are failed, it will require the posting of a letter of credit in order for continued participation in federal student aid following consummation of the transaction. Again, this answer is at a very high level, but the thing to take away is that if you have a transaction and both institutions or one institution is having financial challenges, you're going to have to carefully consider what will be required to get the approvals you need. And now I'm going to turn it over to my colleague, Ellen Babbitt, who's going to talk more about financial issues and specifically talk about financial exigency. Ellen?
Thank you. Now I'm going to turn to the next question, a financial exigency question. What are the limits upon a board's ability to address financial issues through layoffs, program change, or changes of control? And the answer here is that there are a number of limits. In part, that's because higher ed participates in the federal financial aid system, so it's highly regulated. And we have a number of commitments to creditors and vendors, like any business. And we also, most of us operate using a shared governance system. So we've actually imposed upon ourselves a number of limitations and structures that need to be honored when we're discussing these very big issues. So there are some limitations. Specifically, first, boards need to be very mindful of legal limits, federal, state, and local laws and decisions. And these may affect our ability to take immediate action. An example is a WARN Act, that's W-A-R-N, WARN, which is a federal or local law requiring advance notice if a certain number of employees will be laid off at once in a particular community. That's just one example of many. Second, we also have accreditation commitments and regulatory requirements that we need to honor in any kind of a program change or change of control situation. Because we draw down federal funds, we have corresponding accreditation requirements. And simply speaking, they can be significant in these situations. For instance, if we close a program, we have an obligation to try to teach out students or make arrangements for them to transfer. We have to give notice. We have to work closely with accreditors and regulatory agencies. Third, boards may be limited by the institution's obligations to creditors, bondholders, or stakeholders. For instance, sometimes there's a bank or a bondholder or even a founding religious order that has rights when an institution wants to make a big change. Sometimes they even have veto rights. So we need to be mindful of these relationships and these requirements. Finally, a board is limited by the institution's own bylaws, policies, handbooks, and program descriptions. For instance, if we, and many schools have done this, have adopted policies allowing the faculty to be part of the consideration process for a program change, we should honor these policies if it's at all possible. So, in short, there are legal, accreditation, financial, and policy limits to how a college or university board can respond in a financial crisis. And we need to honor these if at all possible. Our next question is related to the prior one. What information and resources do your leaders need before implementing layoffs, program changes, or changes in control? I'd start by noting how critical it is to assemble that information, assemble those resources, and plan before you make decisions. Specifically, we want to identify and assemble information, identify, assemble, and use our resources, and educate decision makers. Plan and educate before choosing an option and taking action. So first, it's important to assemble the information. That is to say, first and foremost, identify all of your applicable internal bylaws, policies, and agreements that bear upon changes in programs, layoffs, terminations, or changes in control. This is the core risk management imperative. Find and follow your own policies. And of course, it's critical to identify the applicable laws, accreditation requirements, and commitments to your donors, your founders, or your creditors. Second, it's important to identify and use your resources. And there are resources. We just have to figure out what we need and assemble and use them. First, we recommend engaging qualified higher ed counsel. Many of these issues, as you'll see, are unique to higher education because we're a regulated, accredited industry. Second, it's important to engage qualified financial experts if you need them, or educational consultants, depending upon the issue. And something I'd also like to point out, which is often overlooked, is how important it is to plan for effective communication to your stakeholders on campus or off. It may be important to consult communications experts and develop a communication plan before you make a decision. That's because how we make and communicate decisions affects our ongoing operations and our ongoing relationships, morale, and enrollment going forward. Third, it's critical to educate your board and leadership about how this is all going to work before decisions are made. It is important to discuss confidentiality and maintaining privilege. Board members may not know this. Leadership may not appreciate how important it is in this situation. Second, it's important to discuss communicating effectively through designated spokespeople and supporting the decision once it's made. And it's also important that everyone understand the necessity of following the institution's own rules, laws, and accreditation constraints. These, we found, are key to a successful process. Now I'm going to turn this over to my colleague Scott Warner to drill down into the question of financial exigency and program change and how it affects our relationships with faculty members.
Hi there, everyone. My colleague Ellen just addressed some important issues for governing boards and administrators to consider when addressing the financial impact of COVID-19. I'll now address a couple of additional issues that focus on faculty-related considerations, which is obviously an important aspect of shared governance. So first, when it comes to financial exigency, there are both contractual considerations and what we often refer to as custom and practice. I'll discuss these in turn. From a contractual perspective, it is essential to understand how your institution defines financial exigency and what role, if any, the faculty plays in any financial exigency provision that is part of the faculty handbook or that is part of any applicable collective bargaining agreement if you have one. For example, if a faculty member whose appointment may be terminated as a result of a financial exigency declaration has a right to a hearing before a faculty committee before a final termination decision is made, it's important to afford the faculty member that procedural right. As with dismissals for cause when it comes to faculty, any faculty committee almost certainly doesn't have final decision-making authority, but the committee might make a recommendation to the administration, and the administration would then make that decision, or the administration might need to take the termination decision to the board for a vote or a final action. It all depends on what your faculty handbook or other contractual documents say about these kinds of things. Whatever the case may be, it is very important to follow your own procedures. With regard to custom and practice, it's also important to at least be mindful of what the faculty might expect when it comes to financial exigency, regardless of what your faculty handbook or other contractual documents might say. To get some sense of this, The 2013 Report on Financial Exigency, issued by the American Association of University Professors, or the AAUP, is worth a read. I want to stress that unless the AAUP standards are incorporated into your faculty handbook or other contract documents, they are not binding, but they are still relevant from a faculty relations and shared governance perspective. To highlight just a few key aspects of the AAUP's 2013 report, the AAUP's view is that faculty should be involved at every step of the way, including in reviewing multiple years of financial data to assess whether a financial exigency actually exists. Such data might include things like audited financial statements, budgets and cash flow statements, and other measures of the institution's financial health. Faculty should be involved in reviewing, at least according to the AAUP, they should be involved in reviewing and evaluating any alternatives to faculty terminations, such as salary reductions, furloughs, the termination of temporary or short-term appointments, early retirement incentives, and cuts to non-academic programs and units. In the AAUP's view, the faculty should also be involved in identifying any particular faculty appointments that are being considered for termination. Again, this is not to say that you necessarily have to do all of this, but thinking carefully about the faculty's role and being transparent about that is something worth considering. Turning to the next slide here, pretty much everything I just said applies to any decision to close or reduce an academic program or an academic major as well. It's very important to follow your faculty handbook and any other contractual documents to make sure that you understand what process you need to follow. And you also need to consider the role of the faculty, again, regardless of what may be in your faculty handbook or other contractual documents. With regard to the AAUP, again, it's worth considering how the AAUP views these things. In particular, it's interesting to note how the AAUP defines what constitutes an academic program. If an institution is considering reducing or closing a program, that raises a question, what actually is an academic program? And at least according to the AAUP's report that I referenced earlier, it's a recognized academic unit that existed prior to any serious financial situation or financial difficulty. So think about what those academic units at your institution might be. Stated differently, the AAUP describes this as a related cluster of credit-bearing courses that constitute a coherent body of study within a discipline or set of related disciplines. So for example, it might be a program that offers a major or a minor, although that's not necessarily the only way to think about what might constitute an academic program. One important consideration is whether courses in a particular discipline will still be offered after the closure of a program. If an institution announces that a program is going to be closed and then continues to offer courses in that particular discipline, that might raise questions as to whether or not the program is actually being closed. You might still have the option, even if a program isn't being closed, to frame it as a reduction in a particular program, and that then could lead to the termination of various faculty appointments in that discipline. Some view program closure or reduction as being based more on long-term educational considerations rather than on financial considerations. In the current environment, this is obviously all related, given the financial strain under which many institutions are operating. The key with all of these issues is to understand what you are contractually obligated to do from a process perspective and to think carefully about how to involve the faculty from a shared governance perspective, regardless of what those contractual documents might say. My colleague Derek Teeter will now address some key issues relating to the recent federal stimulus bill.
Thank you, Scott. We're going to shift focus now just a bit to a few questions pertaining to the various stimulus programs that Congress has passed in the last few weeks that provide financial support to higher ed institutions along with small businesses. And one of those programs is the Paycheck Protection Program, or PPP as it's commonly being referred to. That provides funds for colleges and universities to essentially cover salary and certain fixed costs like mortgage payments and utilities. And a question that we've had from a number of clients is, do we need to implement new accounting practices for the receipt of these funds? And the answer is probably yes. That would certainly be a best practice. Why is that? The way that these funds are structured, they come in the form of a loan to an institution that will be excused in the future, assuming the institution can appropriately document that those funds have been spent for authorized purposes, to make up for payroll, to cover those utilities, to cover those mortgage payments. And 75% of those funds have to go to payroll, with the remaining 25% being used for those other authorized expenses. Well, there has to be documentation at the back end of this loan to demonstrate to the lender and ultimately to the government that the funds that were received were spent for the authorized purposes for which they were granted. And the simplest way to do that would be to have a separate bank account into which those paycheck protection funds flow, so that then the specific expenditures can be neatly tracked and traced to payroll, to mortgages, etc. If those funds were commingled into an institution's general account, it would become more challenging from an accounting perspective to document the way those funds were spent and ultimately then to have the loan forgiven. So please, our advice would be to speak to your accounting department or outside accounting firm if you use one, also working with the lending institution to try to set up those accounting practices at the front end to make it easier for you to do the documentation you need to do to have the loan excused and for the funds to essentially convert to a grant. So another stimulus-related question that we've received from a number of schools, all religiously affiliated, is the question of whether those institutions are giving up certain of their religious freedom rights by participating in these various stimulus programs, whether it's the Paycheck Protection Program or other COVID-related funding programs that may be coming down the line. This is a smart question to ask because, as a general proposition, when a school receives federal funds, that triggers certain non-discrimination obligations that the institution otherwise would not have. So the most obvious example that most schools are aware of is that receiving federal funds triggers Title IX liability, the obligation to comply with various sexual misconduct reporting and investigative duties. So if you were a school that to this point had not received any federal funds, and there's only a handful of those schools, by accepting these COVID-related funds, you would trigger Title IX obligations, for example. But the vast majority of institutions already receive federal funding in some way, shape, or form. So I think the more precise question is, are we assuming any new restrictions on our religious liberty by participating in these COVID-specific programs? And I think the answer to that generally is no. The guidance from the Small Business Administration and the government has been clear that the government expects and agrees that religious institutions are retaining their First Amendment rights with respect to selecting their pastors, selecting persons in ministerial roles, that they're not altering their discretion to control who is or isn't a member of their religion. And certain programs, for example, Title VII, have religious exemptions already built into them. So I think the government's trying very hard to make clear that accepting these funds isn't going to impact the religious autonomy that these religiously affiliated institutions have generally enjoyed. And with these COVID-related funding programs also being of a relatively short duration, when the institution pays back those funds, it would relieve itself of whatever obligations it had assumed by virtue of receiving those funds. And so in the end, I think it's a temporary obligation if there is one to begin with. So with that, I'm going to transition it to my colleague, Julie Maselli, to answer a few more stimulus-related questions.
Thanks, Derek, and hello, everyone. I'm Julie Maselli in our Chicago office. The question I've been getting regularly from our clients is this: how can we use the student grant portion of the Higher Education Emergency Relief Fund? Some of you may have already applied for and received that first 50% allocation from the Emergency Relief Fund? And if so, congratulations. Under the CARES Act, this first allocation must be spent on direct aid to students in the form of emergency grants. The department has stressed that these funds should be used for student expenses such as food, housing, course materials, technology, healthcare, and childcare. And the department has warned that institutions may not use these funds to reimburse themselves for expenses they previously incurred in supporting students in dealing with the pandemic-related challenges. This has left the higher education sector essentially scratching its head about what seems like unfair treatment for schools that quickly supported students with funding weeks ago for these exact expenses versus schools who are still working to provide that kind of financial support today. We know that this issue has been raised with the department and are hopeful that they will address this in a way that provides more flexibility for schools that have already incurred significant financial burden themselves in supporting students. Until then, the guidance is clear that this 50% allocation must not be used to reimburse schools for their own expenses. This leaves institutions contemplating a number of potential funding strategies for students. Some that I have heard include these: payments for students based on need, EFC, or Pell eligibility, payments for students proportionate to what they paid in their spring term, refunds for spring term expenses such as room and board if they didn't previously provide those, and creating financial incentives for students to use funds towards fall enrollment. We submitted questions about all of these strategies to the department's officials earlier this week and are awaiting a response. In the meantime, given the ambiguity around the guidance and allowability of uses for these funds, these are our top 5 recommendations. First, institutions' leadership teams should be talking together about funding strategies. Bringing together your budget, academic, financial aid, student affairs, and legal officials is a prudent way to ensure that you're considering the advantages and disadvantages of multiple funding strategies and the allowability of those expenses. Second, keep in mind that 75% of your total allocation was based on your full-time Pell-eligible student population. That said, it seems likely that Congress intended these students to benefit from this funding, at least in some way. So any funding strategy that leaves these students out of the mix may not be consistent with the intent of the CARES Act. 3, talk with your counterparts at peer institutions about funding strategies that they are considering and see what they are doing. Essentially, rely on your community of practice. 4, balance your interest in getting funds out soon with your interest in getting funds out fairly and in the most beneficial way. Work quickly, but don't jump too quickly, essentially. And last, talk with your legal counsel. We may have more guidance on these very issues from the department in the coming days, so it may be helpful to take a little bit of time to develop options, analyze advantages and disadvantages and potential consequences, and share those strategies within your community of practice. So the second question I've been getting is nearly identical to the first, but it relates to the specific students who may be getting funds from the CARES Act. May institutions provide higher education relief funds to international students, DACA students, and undocumented students? One thing I want to first note is that this question is a little bit more complicated than I have heard in discussions on the interwebs. Let's take international students for an example. I've listened in on a number of stakeholder calls that conclude that there's nothing in the CARES Act precluding the higher education emergency relief funds from being used to support international students. And that is true. That is how the CARES Act reads. There's nothing on this issue with respect to this particular fund. However, that conclusion may not take into consideration the terms and limitations imposed on those students from their visas. For instance, foreign nationals are subject to a public charge rule, which precludes them from accepting any public benefits such as Medicaid, food stamps, subsidized housing, and the like. And accepting those kinds of public benefits can result in the loss of student status and the ability for those students to re-enter the U.S. It's an important visa requirement, and this public charge rule has existed for decades. And what we don't know right now is if the public charge rule would encompass the stimulus funds under the Higher Education Relief Fund. As a matter of course, many such students just simply may take the approach of always declining any kind of public benefit to avoid such problems. And in an abundance of caution, we're starting to hear that some institutions may not be issuing stimulus funds to international students, so they don't do anything to jeopardize those students' visa statuses. The issue here is, again, whether stimulus dollars, which would be characterized for emergency uses, are somehow inherently different to those public benefits that are prohibited under the public charge rule. We have asked this question of the department and are awaiting a response. Our initial thinking is that stimulus checks may be viewed differently than other public benefits, essentially as an emergency fund, and might not trigger a public charge violation. But even then, DHS, or the Department of Homeland Security, can change this rule anytime. So there's no guarantee that accepting stimulus funds now won't negatively impact a immigration application in the future of those students. But it seems likely that any such decision like that would generate quite a bit of litigation. So let me boil it down to this one takeaway. This issue is a hot potato, and guidance from the U.S. government is needed before we can feel confident about advising schools on this issue. What we are telling schools now is proceed cautiously, notify students to consult their own immigration attorneys before they accept such funds, and also consider alternatives for funding these students outside of these stimulus dollars. As to undocumented students, which includes DACA students, we also think that this is still an open question. And we're hearing even as early as this morning that there is some discrepancy between staffers on the Hill across the entire political spectrum. So we really do need verification as to whether DACA students would be eligible to receive these sorts of funds. One thing I can say is that the verification that schools have to sign in order to receive this first allocation requires them to comply with all applicable laws. And there are similar laws that preclude public benefits being provided to undocumented individuals. So we have essentially the same analysis here. So as soon as we have more information, we will be sharing that. These are important questions, and I hope I've given you some practical information on how you may approach this issue. Last, and before I turn it to my colleague on some contracting questions, I just want to flag that we are awaiting more information from the department, not only on this first allocation of the Higher Education Emergency Relief Fund, but also the second, which will be a much more flexible portion of money for institutions of higher education to use to support them in their COVID-19 related challenges. Finally, we're monitoring developments in DC on what may be a phase 4 of the stimulus program that we anticipate coming forward in late April to mid-May. And some discussion on the Hill already about this includes some protections for DACA students, expansion for healthcare funding, broadband infrastructure, and additional small business funding. We'll keep monitoring this and share information on phase 4 of the stimulus as it becomes available. With that, I will turn it to my colleague and contracting guru, Sean Tassi.
Thanks, Julie. I'm going to address 2 questions today, both of which relate to third-party service agreements. So the first question is, my dining service provider is asking that we modify our current agreement to accommodate issues related to COVID-19. What are some practical considerations as we analyze the request? This is a great question, and one that we're starting to field more and more over the last week or so. From my perspective, dining service agreements are long-term deals. Most of the agreements commonly last 5 or 10 years, and many contemplate auto-renewals of those length of times as well. As such, we're talking about a business relationship that has been in place for an extended period of time, and one that will likely be in place well after our lives return to normal, although I know it doesn't seem possible right now. But an important point that should not be overlooked is this business relationship, and the vendor should be looking at it that way as well. With that in mind, I've been talking with clients who ask this question to analyze how changes to operations due to COVID-19 will impact each party under the current contract in the very near term, weeks, the nearer term, a month or so, and in the midterm, maybe the remainder of the year. These answers are going to vary greatly between institutions based on your specific terms of your actual agreements. For example, has your institution guaranteed a certain number of meal plans that will be purchased each term regardless of whether students consume them? Has the vendor guaranteed a minimum amount of revenue to your institution regardless of how many meals they actually sell? which party owes money to the other party at the various stages of the contract based on the impacts of COVID-19 will help you start having some of these difficult conversations with your vendor. The next thing that I would look at is both parties' termination rights, limitation of liability provisions, and dispute resolution provisions contained in the agreement. For example, does the contract contemplate unforeseen circumstances that require the parties to meet and discuss the changing circumstances and figure out a solution that is agreeable to both parties? Or can one side drag their feet until notice of termination is sent? Similarly, did the dining service provider provide the institution with capital for improvements that must be paid back immediately if the agreement is terminated by either party? If so, those are the type of issues that would be important to factor into when evaluating your institution or the vendor's particular bargaining power. Again, these provisions will vary greatly based on the contract. Once you better understand how both parties will be impacted under your current agreement, you'll be in a much better situation to start the hard conversations and to develop a plan to modify your agreement moving forward. Whatever the parties decide, we recommend memorializing that agreement in writing. And a final point on that is, don't necessarily feel the need to reach an agreement now that addresses the rest of the year or some length of duration. It may be helpful to reach a short-term solution now with the understanding that the parties will need to continue conversations about longer-term resolutions as more information becomes. My second question is, as we start thinking about our summer and fall, how will those decisions impact our various service agreements? This is another good question. To me, from a legal perspective, this question is starting to circle back to force majeure type concepts and considerations in a lot of ways. Derek touched on force majeure during the first town hall webinar, and our HB colleagues, Jamie Mathis, Katie Giannisi, and Wendy Proctor did a great in-depth webinar on force majeure and the doctrines of impossibility and frustration a couple weeks ago. So if you want to do a deep dive into those concepts, their webinar is available on the HB COVID page and is really a great resource for that. But for purposes of answering the question today, we're really talking about timing from my perspective. Force majeure, impossibility, and practicability, and other legal concepts such as these that provide an excuse for performance to a contract typically require an event that makes the performance impossible. So as you start thinking about summer and fall, you're probably trying to make decisions based on assumptions. And those assumptions ultimately may or may not be correct. For example, how long will shelter-in-place ordinances remain in effect? Will a vaccine be developed sooner than expected? Will supply chains be impacted? And if you make an assumption that is not actually correct before the triggering event really occurs, force majeure concepts may not provide the same protections that they did 3 weeks ago. So you can't lose sight of the timing of your decisions. As you're making decisions that impact summer and fall, you need to be looking at your contractual obligations under your various agreements as well. In some circumstances, you may be able to cancel some of the contracts now or in the near term. Look at the termination clauses and auto-renewal clauses contained in those agreements to make sure that you send any required notices to terminate if possible. The analysis around agreements that don't contain favorable termination clauses will be a little more complicated, but the analysis will be similar to the dining services questions that I just addressed. Again, the key is understanding your contractual obligations so that you can make informed decisions around them as you move forward. So with that, I'll turn it back to Haley.
Thank you, Sean, and thank you to each of our attorneys on the call today. As you all know, these issues are evolving on a daily basis, and our team is working hard to keep you up to date and to stay ahead of the regulatory challenges that you are facing. As we are moving forward through this crisis, we want to continue to offer you other resources, including additional webinars. Our next webinar will be offered on April 21st from 2 to 3 p.m. Central Time that will focus only on labor and employment issues. And we'll have Kate Levesque and Brian Zickafus, our partners within our higher education team, talking to you about labor and employment questions that are coming up during COVID-19. And with that, I'm going to turn it over to Mary to talk a little bit more about other resources. Mary?
Thanks, Haley. We do have a couple of more resources we're happy to share with you. We have 2 dedicated websites. The first one is a landing page for COVID-19 related content across all practice areas that the firm has put out, which also includes higher ed. And I think you'll find some helpful information there. Secondly, the firm has launched a separate website to provide content to help clients regarding the CARES Act that we touched briefly on in this webinar. We add content frequently to both of these, and so I know you want to check back on that. The links to both resources, you'll find it on a handout that has this slide in there for you, so you can find that easily. We also have if you have specific needs, you can also contact your Husch Blackwell attorney, or we've got a dedicated education email address for COVID-19 issues, and you'll see that email address there as well. Again, we want to thank you for joining our program today. We appreciate your time during these challenging days, and we hope that this information was helpful for you and your institution. If you have not already, please click on the survey icon at the bottom of your screen and complete our short survey to help us with feedback for future quality programs. As a reminder, this program is approved for continuing legal education credit for Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas. We are still pending with Wisconsin, and once it's been approved and everything's ready, we'll update the link with the certificate that you'll receive in an automated email tomorrow. We'll also send you a link to a recording of the webcast, which will be available tomorrow as well. This concludes our webinar. We do want to wish you all the best. Be safe and take care. Thank you.